next frontier in personal finance, right? What does it matter whether my rate of return is 3, 4, or 5% if I have a 43% chance of losing assets to a contentious divorce? I have a 60% chance of losing assets to a long-term illness. So we really want to think about structures, legal structures to protect ourselves and protect our families. Now, we know statistically, when the economy is bad, lawsuits in general go up. We're a very litigious society, and that is increasing by the day. We see ads from ambulance chaser attorneys every day, and new and ever more inventive ways of suing each other are emerging. So we really need to know about laws beyond simply doing a will, right? 30 years ago, you did a will, that was it. A will determines who gets my stuff when I pass away. But what happens if between now and the time that I pass away, I have legal liabilities, I have long-term care issues, I have, matrimonial issues. But the single biggest chance of litigation is with a loved one. Did you know that? That statistically, we are all more likely to be in court with a loved one than a stranger. And that happens through a contested will. If my mother leaves my brother more because he's a neurosurgeon and I'm a social worker not making that much money, we can expect a little battle on the other side. So it's very important to learn about legal protections. And some of you know by way of background, I was a New York State Assemblywoman for 14 years, and I chaired the task force on trusts. So we are going to spend a little bit of time talking about how trusts can protect our families and protect our assets from liabilities. But I will share with you a little bit of irony that I am dedicating my professional career to asset protection. And my dearly beloved late grandmother was, her pastime was suing people. She was the slip and fall queen of Bensonhurst, Brooklyn, and she had it down to an art form. And if there are any relatives of mine on the Zoom, you're going to take issue with me sharing these stories, but she would, at a wedding, maybe have a little too much to drink. And if anyone here is old enough to remember the entertainer Charo, does anyone remember Charo? Well, after a few drinks, my grandmother did her, what she called hoochie coochie dance out on the dance floor. And if there was a fall, she would sue that establishment. So I think I grew up feeling a little icky about these lawsuits, and and aside, her other hobby was you never wanted to go to a restaurant with her. Does anyone remember Beefsteak Charlie's? Anyone old enough to remember that?
Absolutely.
Well, they had this all-you-can-eat buffet, and
Shrimp.
if you went with my grandmother, you certainly didn't want to go to the buffet with her, because she would whip out a little bag from the produce section at the supermarket, and she would pocket as many shrimp as she could. And when the restaurant went out of business, she said, "That was a shame about Beefsteak Charlie's." I said, "I think it was your fault. You were taking all of the shrimp." But anyway, we need to really think about how we can best protect our families. And when we think about protecting assets, I like to think in terms of 3 separate categories. Category number 1, you've all come into this meeting partially protected if you have retirement accounts. If you have an IRA, a 401k, a 403b, a SEP, if we have any teachers, if you have a TDA, your retirement accounts are the best protected asset you can have. From general liability, we have very strong federal ERISA protections, and in New York State, your monies in a retirement type account are invisible in the event that we need to apply for a long-term program. So let's move retirement accounts to the side for a moment. The next category that we want to think about is real estate, including our primary residence. And there's a lot of horrible information out there about the home and what you need to do to protect it. So let's jump right in here. What we want to avoid is going through life with real estate in our own names, because you're just a sitting duck for a lawsuit, whether it's the mailman or an Amazon delivery person tripping and falling on your front steps. They're able to sue you. You have homeowners insurance, terrific. Make a claim. You're not going to have homeowners insurance anymore at a reasonable price. So we want to think in terms of structures. And you've all heard the term trust. You've also heard the term LLC, S corporation, limited liability partnership. And what all of these entities have in common is that they protect the assets that are in them. For the primary residence and also vacation properties, you can have more than one property in the same vehicle. I like a trust, because if I am going to put my primary residence, my home or the shares of stock of my co-op, if I put them into an LLC or an LLP or a corporation, depending upon your county of residence, you can and probably will lose your STAR real estate tax exemptions. So for the primary residence, I like a trust. Is the trust, and you've all heard the term trust, and you've heard the next two terms, is the trust that we want revocable or irrevocable? And my smart aleck answer is neither one, right? You definitely want something in the middle. So a purely revocable trust is very appealing psychologically, right? I'm my own trustee. I can order one off of late night TV from Susie Orman, and I'm all excited. My kit comes, and with the revocable trust, I can put assets into it. I can take assets back out of it whenever I want. Well, if I can get my hot little hands on the revocable trust assets whenever I want, so can my creditors standing behind me. So can my nursing home. So can my soon-to-be ex-husband. A revocable trust does one thing only. It avoids probate. Okay, and it is a very good idea to avoid probate. If that is your only goal on this earth, then a revocable trust makes sense for you. But if, in addition to avoiding probate, we also want to protect the asset in it from liability, including long-term care claims, then we need a stronger trust. Okay, one of the big fallacies out there is that the trust does not have to be purely irrevocable. A purely irrevocable trust is never necessary, and it can cause some harm. If I name my 3 children as the beneficiaries of a purely irrevocable trust, and one of them is in a lawsuit, their future interest can be attached. If One of them, God forbid, predeceases me. Now I don't have the ability to control where my late son's 1/3 is going to go. He has a will, and it says what? It says everything goes to my daughter-in-law, who I may not be on the best of terms with. And even if I am, she's going to get remarried. And now that 1/3 is to the four winds. So you never need to do a purely irrevocable trust. You should never put something together where you don't retain a set of handcuff keys. Does that make sense? So then the question comes up, why does anyone do a purely irrevocable trust? And I believe that the answer is many attorneys don't know where on the spectrum they need to stop. So, better safe than sorry. They go for full throttle, purely irrevocable trust. And in the book that we're going to raffle off at the end that I wrote, that Dr. Phil wrote the foreword to it, in the book I tell a true story about an attorney that I am social friends with. Oh, you know what? I made a mistake, Sarah. That's actually the old graphic. I emailed you the new graphic 5 minutes before. So that was the graphic that my publishing company was going to use before they learned that Dr. Phil was going to write the foreword. And now all of a sudden, Anne became a little less relevant and they wanted Dr. Phil in there. So the book cover is a little bit different. We'll raffle it off at the end, but I'll just put it out there that I will give you my personal email address. The way to enter the raffle and receive updates from me, you don't receive a ton. I recognize a few of you, you get my updates. I would say 4 to 5 per year. So if you send me an email to Ann Carrozza, so no Margaret, ANNCARROZZA@AOL.com, and just say hello and you'll be entered to win a book. And if you want to be on the update list, let me know that.
I have a question. If I put a house into a trust, irrevocable, and I die, will my beneficiary get step-up basis for that house, or will it cost remain the original one?
It depends on how the trust is drafted, and I'm going to come right back to that excellent point. So in the book, I tell a story about an attorney that I am social friends with to this day, a kind of person before the pandemic, you'd hug them and kiss them when you saw them at a party. And he practices personal injury law. And he called me one day that he was doing a trust for someone. Would I look it over? So, frustrated teacher that I am, I take the document home with me that weekend and I'm on the couch marking it up. And it was the legal equivalent of a horror movie because he's referring to provisions of the Internal Revenue Code that were repealed in the 1970s. So it was readily apparent to me, playing Columbo, that he got this document from some retired or deceased attorney's files, had his secretary cut and paste the names. So the document looked beautiful. It had the names spelled correctly of his client, but it was really a piece of garbage. It was 25 pages of garbage. So now I'm in this Dear Abby quandary. What do I do? Do I tell him what? So Monday morning, I called him and I said, I really need some more information about the client to give you a better sense of, what to do. So he proceeded to violate every tenet of attorney-client confidentiality, and he faxed me chapter and verse, account numbers, social security numbers, on and on and on. So I drafted a different trust for this client and I sent it over to him, and you know, I think there was a little bit of a male-female dynamic going, because even here, I'm afraid of hurting his feelings. So I said to him, I made some changes. And his response was, oh, at least I was on the right track, so that's good. Okay, so I hung up, and he then puts out a shingle that he's doing elder law. And I just cringed, and it really hit home for me that this practice of law, perhaps more than any other, is like the Wild West. You can have someone who looks good, who sounds good, but in the trust, it could be a piece of junk. All right, so this is an example of someone who would do a purely irrevocable trust. And in a purely irrevocable trust, your beneficiaries will have a tax problem, because if I bought the house for $50,000 and it's now worth $350,000, and I make a gift to the kids during life, or I make a gift to a purely irrevocable trust, the beneficiaries will have to pay capital gains later. So we do not even want to think about a purely irrevocable trust. You want to be somewhere in the middle. And technically, it is a hybrid with elements of being revocable and one tiny element of being irrevocable. In order to protect the assets, and in order to get this magical 5-year clock running for long-term care and nursing home purposes, the trust that I set up for my house must appoint another person. I cannot be my own trustee. So I must appoint Sarah as my trustee. But if the trust is properly drafted, Sarah cannot look right and she can't look left without my written permission. So she's like a bouncer at the door, and she comes into play in only one situation. If I want to sell the property, she can't sell without me, but I will need the signature of my trustee in order to sell the real estate. So what happens if Sarah is on a trip, or we've had a falling out and I don't feel like calling her, or she doesn't think it's a good idea for me to sell and I can't easily get her signature? If the trust is properly drafted, I will have retained the right to remove and replace my trustee for any reason or no reason. So that is a critically important power to retain. If I only need her to sell, and if I can replace her with a yes man or a yes woman whenever I want, then that's not really a big consequence. But legally, down the road, 5 years and 1 day from when I sign it, I am able to say to a hypothetical nursing home, or to my husband's hypothetical nursing home, we can't get at it acting alone. And that is legally true. We need the signature of our trustee to grab the house back out of the trust, right? So that is, I think of it as 1% irrevocable, but in reality, I can even control that piece of it. We also want to retain the ability to change our beneficiaries. So naturally, I'm going to start off, or my husband and I are going to start off with the 3 children as the beneficiaries. But if we retain the ability, now I'll throw a tiny bit of legalese at you, it's called a special power of appointment. If we retain a special power, think of it like you're holding the puppet strings. You're naming the 3 kids, but you retain the ability to reallocate the remainder interest between and amongst your named beneficiaries lineal descendants and trusts for their benefit. Why do I want to do that? We don't know the curveballs that life has in store for us, and we want to be able to react. If my daughter, as a named trustee, develops a substance abuse issue, she becomes a wild woman spending money, she's on her fourth marriage and wants me to help her pay attorney's fees yet again. If we have any problems, we want to be able to build a little trust that will protect our beneficiaries after us. But the real reason why we want to retain the ability to change the beneficiaries is to protect my home and whatever else I have in the trust from their liabilities. If my child had a car accident or ran a child over on a bicycle, God forbid, and he's about to be sued, if mom retains the legal right to remove him as a beneficiary of the trust, then none of his liabilities can attach to the asset. Does that make sense? So in this hybrid trust, because the parent or the grantor retained so many powers, it's going to qualify under the Internal Revenue Code as what's called a grantor trust. And because I retain 100% of the ownership rights of the house, Sarah as my trustee and my kids as the beneficiaries can't come in my home without my opening the door and allowing them in the home. They have no rights to the house. Because that's the way this trust is drafted, you will keep your star property tax exemptions, and you will also enable your children many years from now upon death to benefit from the step up in basis for capital gains. So that means if I bought the house for $50,000 and at the time of my death it's worth $550,000, when it comes out of this trust, the kids take it with no capital gains to speak of. Does anyone have any questions on that piece of the trust residence?
Yes, can you repeat that again, please, about the step up?
Yeah, so the step up in basis is in the Internal Revenue Code. It's section 1015, and it holds that assets passing because of a death go to the new owner with a cost basis equal to the fair market value as of the date of death. Does that make sense?
Yes. What
So
do you
we wouldn't have any capital gains.
What do you include in the trust, or what provision that can happen?
Well, there are many provisions, but the number one provision is retaining 100% of the use, the occupancy, and the ownership rights. So if we don't retain 100% of the ownership rights within the trust, A, we're going to lose our property tax exemptions, and B, we're going to inflict carryover basis on our beneficiaries. Okay, any other questions on the trust?
I have a question.
Yeah.
As you said, the trustee, let's say with a nursing home, they can't come to you, but they can go to the trustee to get the property? Is the trustee in jeopardy of any legal?
Okay, no. So the trustee does not have to listen to anyone but the grantor. The trustee has no liability, and they have no ownership rights in the property. So the trustee is a stranger to the nursing home and the nursing home's claims. So the nursing home has absolutely nothing to do with the trustee, and provided that we've gotten this magical 5-year clock under our belts, the property in the trust is 100% invisible to nursing home claims. Now, let me just pivot for one moment to this third category of assets. So we have the retirement accounts. You all get a check mark on that. It's invisible. It avoids probate because you have a beneficiary on it. The real estate, I think only crazy people should own real estate in their own names in these days. Then the third category of assets are regular money in the bank, a checking account, money market, a brokerage account. Most of us want to retain ownership of these assets. As much as I like Sarah, I don't want to put all of my money in the trust because I would have to call her to get money out of it to go out to dinner or get my hair done. So we want to keep the money outside, but it's important to set up power of attorney. Critically important, because if we have a good power of attorney, and even husband and wife need power of attorney over each other. If my husband and I have a joint CD and he dies, it's a non-issue legally, right? Because it all comes to me. But if instead of dying, he had the bad luck to have a long-term illness, now you better believe I need power of attorney to go to the bank, cash the CD out early, and quickly move it into my name. So this 5-year federal look-back period does not apply between husband and wife, okay? Now we are expecting the 5-year look-back to be increased. Some of you remember it used to be a 3-year look-back. Then in 2006, it became a 5-year look-back. There are bills in Congress right now, alternating bills, one that would make it a 7-year look-back and one that will make it a 10-year look-back. And on the New York state level, we are looking down the valley of a $15 billion budget deficit. The federal, I can't even count that high, but I think, you know, we're going to see a contraction of the ability to get onto these programs. So everyone has Medicare. Most people have a Medicare supplement, but if we need to be in that rehab facility or my spouse needs to be in the rehab facility beyond the 100 days that Medicare and the supplement will cover, we need a plan. And if we don't have long-term care insurance, and you can reach out to me offline if you want to discuss long-term care insurance. If you don't have that type of insurance, it's critically important that your assets be protected and that we're able to do an interspousal transfer. Now, most of us, and I think especially women, and on my website, which is myelderlawadditorney.com, I have an article posted called Estate Planning and the Single Girl, because as women, no matter what our current marital status is, we said already we have a 43% chance of being divorced. We have an 80% chance of surviving our husbands. So it's very important that we get as much information as we can, and that's what we're all doing today. We're sharing information to protect ourselves later on. What can the Ann of today do for myself to protect the Ann of 20, hopefully 30 years down the road, so I'm not at the mercy of other people's decision making? So that brings me to healthcare advance directives.
And before you go,
yeah,
just because you're still on the other topic, the question I had was, if your child does something that could cause a liability to the trust, and you want to remove that child as a trust as a trustee,
beneficiary. No, as a beneficiary.
can you remove the child post-incident and be protected, or did they have to be removed prior to the incident?
Okay, no, you're making an excellent nuanced point. If I run over a kid on a bike, God forbid, I am not then free to get rid of my stuff, right? That's a fraudulent conveyance, and timing is everything. If, however, my mother retained the ability to pull me out as a beneficiary whenever she wants, that means legally that the transfer into the trust was not a completed gift to the trust. So on the front end, that means you don't have to do a gift tax return, right? So think about it logically. If mom or mom and dad retain the ability to remove a beneficiary, that pinball has not finally landed. So if one of the named beneficiaries is being sued, we don't even have to go through the exercise of removing the child as a beneficiary. All I have to do as your attorney is send a copy of the trust to the plaintiff's attorney, showing them this special power of appointment. And it's as good as if it had been exercised, because they just back off like a frightened ghost. They know they can't get at it. And that protects the assets in the trust 100% from the beneficiary's future possible problems. Now, I think a trust is not a DIY job. It absolutely is not, because everyone's situation is a little bit different. And when I work with someone, and a few of you, I recognize some of my lovely clients on the call, I ask you personal questions that maybe your therapist doesn't ask you, because it's very important that I know if you're not that fond of an in-law, or that you have kids who haven't spoken, for 7 years for whatever reason. All of these things need to be nuanced within the plan. What is a DIY job, and I think attorneys who charge for a healthcare proxy should be ashamed of themselves, because it is designed to be user-friendly. I have a healthcare proxy you can print off of my website, and you're simply appointing another person to make decisions for you in a hospital setting. They can make every decision under the sun, including whether or not to withhold life-sustaining treatment. Now, in New York State, the healthcare proxy is 100% legally binding on a hospital. We don't have as strong a living will law as some other states, including Florida, has. And the reason for that, I was in the legislature at the time, and the medical society didn't want their doctor members having to read through my 5 pages of layperson rambling within the living will. If I thought it was as clear as day to say I want no tubes, the medical providers are wondering what kind of tube is she talking about. So in New York State, a living will is some evidence of what the person wants. And again, on my website, I have my living will there. You can download it, you can change the language around, but really the living will is a guide to those who are going to be responsible for my care at a point in time where I'm not up to the job myself. So what I do within my living will, and I encourage all of you who feel the same way to put this in your living will, I say, A, if I'm asking for aggressive pain medication, I don't care that I just had it an hour ago. If I'm asking for more pain medication, please give it to me. And that's going to relieve some liability concerns on the part of the medical team. I also say within my living will, in the event that I need care, I wish for my care to be provided in my own home unless it's not possible. So the care that we're talking about is usually not medically complex. It's, you know, when we need help with the unglamorous functions of activities of daily living, feeding, bathing, dressing, toileting. Those jobs, those tasks can be accomplished in a person's own home. And think about it, especially if we ever develop a cognitive issue, a dementia-related illness. Am I going to be happier in my own familiar surroundings of the past 40 years? Or in a nursing home with a wacky roommate and food that's not even palatable? And we've seen during the pandemic just how horrible facilities can be in terms of, you know, transmitting diseases like wildfires. So I feel very strongly that, you know, the professionals amongst us on this call should do everything we can to keep our clients, our friends, our family members, and ourselves in the community, in our own lovely homes. And there are things we can do to promote that. And, you know, before turning it over to Sarah, that is what NYSARC is all about. It's about enabling folks to stay at home, stay in the community, and bring resources to the person. So New York State's Medicaid program, and you know, for the baby boomers amongst us, for those who are younger than baby boomers, I don't believe this program is going to be around in its current state 10, 15 years from now. I simply don't. The writing is on the wall, and those of you who are young enough and healthy enough, you should really consider long-term care insurance. At the very least, go talk to someone about it, get information, put the information in your file folder of, you know, the future care and feeding of me, right? And accumulate information as we go along. New York State's Medicaid program right now is the best in the United States. It is illegal for a nursing home in New York State to differentiate between us because I'm on Medicaid and you're private pay. The care within a nursing home is 100% identical. My husband happens to be a geriatric physician. He's the medical director of a couple of nursing homes. And on one of our early dates, I asked him, because I was skeptical, you know, is the care really 100% identical? Or do you have, you know, generic Band-Aids for me and better Band-Aids for the guy next to me? And you can have crummy facilities and better facilities, but within the facility in New York State, the care is identical. Now, when we talk about Medicaid, home care, community Medicaid, some people recoil thinking that the program is going to send Frankenstein to the house. That is not the case, because every county in New York State has contracts with home care agencies. And they're not making a contract with an agency that has any kind of sketchy record or complaints. So they are making contracts with the visiting nurse service, top level agencies in all of the counties. And beyond that, there is something called the Consumer Directed Program. I can hire my own person, and Medicaid will pay that person provided that they're able to work in the US. So the good news, bad news here is that it is quicker to qualify for community Medicaid than it is for nursing home Medicaid. The look back period for community Medicaid, there technically is not a look back period, but we say that there's a 1 month look back because we want to be able to show a series of clean bank statements to Medicaid. So today, if I were to take my house and put my house into this asset protection or this hybrid trust, and my retirement account is already protected, and we transfer my interest in most of the category 3 assets to my husband, and we get me down to below $15,750 in countable assets. Again, retirement accounts don't count. And we do this today. And I apply for Community Medicaid next month. We are good to go on the asset side because they don't look back. But as part of this year's budget, New York State budget that was passed in April, pre-pandemic, when we were only looking at a $6 billion budget deficit, the decision was made to extend the look-back period for Community Medicaid to 30 months or 2.5 years. That was originally supposed to take effect October 1st. It's been postponed to January 1st of 2021. So everyone does have this tiny window to get cooking and at least get the assets protected. And it's doing double duty to also get the longer 5-year clock going so that when it does turn to 7, you'd be grandfathered under the 5-year regime. So that's how we qualify the assets. The income, there's a very low income threshold for Community Medicaid. In the old days, you only had 2 choices: give Medicaid the overage or go without care. So you'd balance, what is the cost benefit analysis here? And maybe I had to give up $2,000 a month of income. Now, I'm going to turn it over to Sarah. NYSARC is a pooled trust company. It's a private not-for-profit company that I've had occasion to use in my own home, and I recommend it wholeheartedly. It allows us to take what is the overage of income and contribute it to a pooled trust. And with that, we'll pivot to Sarah to explain. We're going to come back to other questions after Sarah does the... Okay, Sarah, would you like to have the unenviable job of explaining pooled trusts?
Absolutely, and I do just want to let everyone know we are monitoring the chat as well. We see that there are a couple of questions there for Ann-Margaret. Once I go through my portion of things, we will open things up for Q&A at the end, and we'll make sure we touch on as many questions as possible. And again, if we will make sure our contact information is available if there's anyone that has questions after today's training that they would like to us to follow up on. So with that, I'm going to just share my screen quickly because I have some slides to share with you all. So thank you so much, Ann-Margaret. That was such a detailed overview of the many facets that go into planning for the potential of needing long-term care services later in life. And I think what everyone hopefully will walk away from this training understanding is that it is absolutely essential with these new changes coming that we are planning for these things as early as possible. So you are all here who are participating in this call are already ahead of the game in that regard. And so, there are many ways, lots of different ways that you can protect your assets and appropriately spend things down to become financially eligible for Medicaid services. And the challenge then becomes for so many families, income is still above the financial limits on a monthly basis. And as Ann-Margaret stated, New York's Medicaid program is extremely robust. And but unfortunately for many people who are looking to apply for these services, if their income exceeds these limits, for a single individual, it is $895 for a person who has a qualifying disability because there is a $20 disregard. For someone to live on $895, is very difficult anywhere in New York State, especially in these downstate regions. When we think about the cost of a mortgage or their rent, or then not to mention utilities and all the other basic living expenses that they have. And so what a pooled trust does is gives people a way to be able to spend down to become eligible for these services. If their income, which is going to come from a variety of different sources, it might be Social Security income, retirement income. It could be Social Security disability income for someone who is disabled and receiving Social Security disability payments. But it may also be, other sources of income, things like a pension, alimony payments that someone may be receiving, and required minimum distributions from an IRA. All of these sources of income that someone has are going to be added up by the Medicaid office to determine what someone's total monthly income is. And if they have income that exceeds the limits based on their category of either being single or married individual, they need to spend down that money before they're eligible for Medicaid to pick up the costs of their care. And so when somebody has excess income on a monthly basis that needs to be spent down, they have a couple of different options. The first, and certainly the simplest, is to take the amount of income that they have over the threshold and deposit and cut a check to Medicaid each month. Simply send that money to Medicaid. In that way, they're kind of paying a premium for their Medicaid services. Another option is to use that money for medical expenses. Things like going to the doctor, paying co-pays, holding on to those receipts and submitting them to the local Department of Social Service to show that proof that you have paid up to the amount of your spend down in medical bills. In that way, you're kind of sharing in the costs of your medical care. But unfortunately, in neither of those options does the individual have the ability to use that money for the things that they need that money for, like paying for their mortgage or their rent or their electric bill, things like their cable or cell phone, and just basic living needs like groceries, personal items, over-the-counter items. And that's where the third option, in New York State, we are one of very few states in the country that allow the transfer of income into a pooled trust to allow someone to become financially eligible for Medicaid benefits. And what this does is it enables people with disabilities and older adults who are seeking Medicaid services to be able to qualify financially for this program and continue to use their monthly income for their daily living needs. Now, a pooled trust is a special type of irrevocable trust. Now, Ann-Margaret gave a great overview of irrevocable versus revocable. A pooled trust is an irrevocable supplemental needs trust in order to protect the eligibility for benefits. If this was the type of trust where you could set it up and take the money in and out as you wish, it would be considered available to you. And so that is why this trust is irrevocable, meaning that once it's established, the trust company cannot simply return the funds to the individual for the protection of their benefits. This is a type of supplemental needs trust, also referred to as a special needs trust, because it is designed for people with disabilities. Now, in order to participate in a pooled trust, you do have to have a disability under the Social Security Administration's definition. And that's really important to point out because I think a lot of older adults and seniors, any seniors who may be on the call, might immediately think, well, I'm not eligible, I don't have a disability. Many of the things that go along with getting older, the chronic conditions that someone might develop, the need for assistance with activities of daily living, like clothing, bathing, and cleaning the house, those are typically going to be things that would make someone eligible to participate in a program like this. And it just may require that the individual who's not already deemed disabled might just have to fill out some paperwork with their local Department of Social Services to be deemed disabled in order to participate in this program. And it's important to point out that These trusts are managed by not-for-profit organizations. It is a requirement that a pooled trust is a not-for-profit who is overseeing as trustee the funds and managing the money. One of the major benefits to this is that, going back to that discussion earlier about trustees, you don't have to select a trustee. The trustee is already in place. And in our case, and in the case of most not-for-profits administering this program, these not-for-profits are very well versed in the rules and regulations of Medicaid eligibility and trust administration. So you have a great partner and advocate for you and your family in helping to maintain your Medicaid benefits. This gives someone the ability to qualify financially for services and also maintain that financial eligibility from month to month so that they can keep those Medicaid services active and keep those in place so that they're able to live in the comfort of their own home and in the community for as long as possible. This program can also help provide a lot of relief to family caregivers, whether it's a spouse or an adult child who's assisting their parent. Obtaining Medicaid benefits can provide a host of services that can assist with relieving, providing extra support to the family, getting home health aides, where the family caregivers can get respite, and also be relieved of potentially some financial burdens. We know that a lot of family members often step up to assist in private paying for their parents or a loved one's services. And so getting these Medicaid benefits in place can also assist in that regard. Now, it is very important to point out that with a pooled trust, these are first-party trusts, meaning that it is the person with a disability's own money that is funding the trust, which means that there is a payback provision to Medicaid, that upon the passing of the beneficiary, if there are funds left in a pooled trust account, the Medicaid will have the right to lay claim to those funds. There needs to be a provision in the trust that Medicaid will get any remaining funds in the trust up to the amount of any outstanding Medicaid lien on behalf of the individual, or the funds could be retained by the not-for-profit to support other people with disabilities that are served by their philanthropic mission. So it's important for people to keep this in mind. This is an important tool that can really help someone become eligible for services, make it so that they can use their spend down on a month-to-month basis. And we want to ensure that they are using that on a month-to-month basis, spending down that money regularly to support their living expenses so that there's not a balance in the trust when they pass away. But it is something that's, a nice, extra benefit is that in this case, with these programs, you can know that if there are any funds left in the account and you're passing, they are going to be retained by a not-for-profit organization that can then directly put those funds back into the community to support other people with disabilities who may have encountered similar situations that you have in utilizing these services, and can help those individuals have a better quality of life. So let's give you a quick rundown of how this works. The order of these steps is going to vary depending on where someone is in this process. So we'll start at the top and going with number one, which is really what Ann-Margaret covered in her entire presentation, is doing the planning ahead of time to transfer or protect or spend down by privately paying your resources or assets that would be counted for Medicaid eligibility. So you get yourself down to the appropriate threshold in order to qualify for Medicaid services. If you are not already deemed disabled, if an individual has SSDI or supplemental security income benefits, they're already going to be deemed disabled with the local Department of Social Services. But if you're an older adult who's seeking Medicaid benefits for the first time and have never had a qualifying disability prior to this time, this is where you would possibly need to fill out some paperwork and submit that to your local Department of Social Services to have the Department of Health review your disability status along with your Medicaid application. We typically recommend that people begin applying for Medicaid prior to reaching out and starting to work on a pooled trust. And that's just simply because the Medicaid application process is significantly longer than the pooled trust application. A pooled trust is very quick and easy to establish because the documents have already been drafted and are in place. It's just a matter of filling out an application to join the trust. And these trusts can be opened in about a week's time. However, we know that in some areas of the state, there is some benefits as far as the time it takes for someone for the agencies to review the application if these are submitted together, the Medicaid application and the pooled trust application to the Department of Social Services. And so that's certainly something that we would advise you to speak with a legal professional within your area that understands how your county administers things, or potentially reach out to your local Department of Social Services to inquire about the best option for your family. And oftentimes it does also come down to, the financial resources of the family. We just essentially don't want someone to sign up for the pool trust before they're ready to use it. But there certainly are situations where a family would do that if it makes sense for them financially. Once the Medicaid application has gone in and is approved, the individual has applied for the pooled trust and that is set up, they can begin depositing their monthly surplus income into the pooled trust on a monthly basis. Medicaid will come out and provide an assessment of the care. The documents showing Medicaid proof that the individual is making their deposits into the pooled trust need to go to the Medicaid agency. They need to be aware that you are using a pooled trust to meet your spend down requirement. And then you can begin submitting requests to the pooled trust to pay for your expenses. Now, this is the process if for people who are just here talking about the future and want to understand what they need to be considering. But if you have a client or you yourself or a loved one are in need of Medicaid services now or are already receiving Medicaid with a spend down, you may be able to skip straight to step 4 and begin with that, applying for the pooled trust. Now, I'm not going to play the video here to the right, but I encourage you, we'll send the materials around after today's training to take a look at this video. It's a really great overview of a great pooled trust success story, someone that we worked with here in Rensselaer County, New York, to help her obtain the services that she needed and allow her to maintain her apartment and her living expenses. And so with that, I'm going to give you guys just a quick example that'll help us kind of illustrate how this works from the numbers standpoint. So we have an individual here, Hilda, and she's in need of Medicaid services. She's 80 years old and she is single, meaning that she's not married and she is going to be subject to the single income limits, which is the $895. She lives in an apartment in Albany, New York, and she has a whole host of chronic health conditions that she is in need of assistance. She wants to get a home health aide into her apartment so that she can get some help with some of the daily tasks like cooking and cleaning and dressing and bathing that she needs some assistance with. Her income on a monthly basis is slightly over the financial limits to qualify. However, as you can see, she has very little money in the bank on a monthly basis. And so she really does not have enough money to private pay for these services, but her income is too high to qualify otherwise. Now, what Medicaid will do, and obviously this is a very simplified breakdown of this calculation, Medicaid determines this, and there are many factors that play into the various deductions that someone might have. So this is a very simplified example of this calculation. But what they're going to do is take her total monthly income of the $1,395, subtract out the amount of money that she is able to keep each month, that she is allowed to have and be eligible for financially for Medicaid services, which leaves us with $500 each month that she is over the financial limits for Medicaid eligibility. Now, on a monthly basis, there are costs for the trust to administer the account to pay bills. So we'll subtract out the cost of the trust on a monthly basis, and she'd be left with around $450 each month that she can then use for things like her bills and living expenses instead of having to turn $500 over to Medicaid each month, where she's not able to use that for things like her rent or utilities. the costs to establish a pooled trust are going to vary by different programs. Every program is a little bit different as far as the services that they provide, but most are structured in that they have a one-time enrollment fee to join the trust. All trusts will have a one-time cost to establish the trust. In our program, it's $200, although we do ask people to open the account with a minimum of $300, which allows us to subtract the $200 enrollment fee, and $100 remains to establish the bank account. There are monthly administrative costs for the trustee to administer the account to pay bills, and there are also some nominal bank fees that are charged on a percentage of the balance at the end of the month that typically amount to a couple of dollars, depending on how often someone's using the money. And so every trust will have a fee schedule. Those fee schedules are publicly available online, and you can use that to go through the calculation we just explained to determine about how much money you would have left of your spend down on a monthly basis that could be used for your living expenses. Every trust does have other fees are going to be, really vary for each trust. In our program, we do have a $50 tax and audit fee. This is for us to do the tax reporting on the trust once a year. And we also have an independent CPA firm come in and audit all of our operations to ensure that things are being done correctly on an annual basis. Beyond that, NYSARC charges no additional fees other than direct costs of using the trust for specific services. Some other programs, however, do have a limit on how many disbursements you can submit on a monthly basis to pay bills, and they will charge perhaps extra if you go above that limit. We do not have that in our program. Ours is a flat fee. It covers all trust activity with no limit on how many requests someone can submit. And we also have no annual renewal fees, but that is something that you're going to want to look out for if you are evaluating different pooled trust options. There are some programs that do charge an annual renewal fee, and that's something you're going to want to take into an account in your cost analysis of the pooled trust you're taking a look at. So here's the question that everybody always wants to know is, all right, so you're able to protect my income, but then what can I use this money for? And this is really going to vary specifically based on the family and their bills that they have and the structure of their family arrangement. Things really are determined on a case-by-case basis because there are so many factors that play into what the trust can pay for. But generally, the purpose of these trusts is to pay for things that are for the primary benefit of the trust beneficiary. And what that means is that if I'm in need of Medicaid services and I have a spend down, I'm putting my money into the trust each month, and I can only use that money for things that are for my expenses. Now, if I'm married and we live in the same home, we are not going to prorate expenses between you and your spouse. Those are things where we can pay the full living expenses. But some of the things that do come up is whether or not the bills are in the beneficiary's name. Because again, we have to document all of the disbursements that are submitted to the trust so that if Medicaid comes to us and says, I want to see what you paid out of this trust account, we need to be able to provide them with the receipts and the bills and the documentation. And we have to be able to show proof that we're only using that money for the sole benefit of the trust beneficiary. And so that is really important. It's also important because it helps protect our beneficiaries from being exploited by other family members, by perhaps other people in their life, maybe not a family member, but someone who might be trying to get access to that money. And so in that way, pooled trusts do also serve really as an advocate for the individual. So on a monthly basis, to use the money in the trust, they'll submit requests to the trust with receipts, copies of bills, things that they'd like the trust to pay for. These bills and invoices do need to be either in the beneficiary's name, or we need to be able to show proof somehow that the service or the item was for the beneficiary. And so again, if you ever have a question about what something, oh, could we use the money for, absolutely keep in good contact with the pool trust and just reach out to them and ask them. There's so many things that we can do to help people use the money in the trust. And so we encourage you to communicate regularly with your pool trust to learn about what are the ways that you can utilize these funds. All disbursements do need to be paid directly to a third party because we cannot reimburse the beneficiary or their spouse. We can't give the money back to the beneficiary. That makes the money available to them. That's giving that money to them is going to put their Medicaid benefits at risk. And so what we do is we pay a third party. You send us a request to pay your electric bill, and we pay Con Edison. You send us a copy of your lease agreement and a request to pay your rent, and we pay your landlord directly. Now, we do understand that can create some situations where someone might not be able to just go out and buy something and have the trust pay for that because we can't reimburse them for that purchase. So when a situation like that comes up where someone wants to go out and buy groceries, for example, they can simply put that onto a credit card and send the credit card bill with the itemized receipts for the purchases that they'd like the trust to pay. And the trust can pay the credit card company. So there are ways around this to give our beneficiaries and their spouses ways to use their money and maintain some level of control over their finances. They're not giving up complete control of their income. They're simply depositing their spend down into the trust, and the trust will work with them to identify the best ways to use that money. One of the other key rules beyond the fact that the things that the trust money can be used for have to be for the sole benefit of the beneficiary, and that it has to go to a third party and cannot be used to reimburse a beneficiary or their spouse. We cannot pay for items that are provided through Medicaid or other means-tested benefits because this is a supplemental trust. It's meant to supplement the benefits that someone's receiving. And so for people who are looking to apply for Medicaid benefits, community-based Medicaid services, this really doesn't come up too often, but I do mention it because we have a lot of people right now who are in need of Medicaid services, and they're struggling to get the hours that they need from Medicaid. Medicaid only authorizes 60 hours a week, and the family knows that their loved one needs far more than 60 hours on a weekly basis. And so we do have some families who want to be able to use their excess income to private pay for additional home care hours above and beyond what Medicaid is providing. And so that is something that the trust could be used for if those payments are being processed through an agency. The trust cannot act as an employer, and so we cannot pay an aid directly, but we can pay an agency that is employing that aid, or we could also set up an arrangement where the family serves as the employer and uses a payroll company perhaps to pay the aid. So that's something that I think is really important to mention, and something that I think a lot of families could potentially utilize and be aware of that is available. Another thing I want to just reiterate as far as the fact that we cannot reimburse a beneficiary or their spouse, we can reimburse another person. So if we have an adult child who is taking care of her mother and she's helping her with her expenses, she can pay for certain expenses and then seek reimbursement from the trust, where she goes out and buys groceries for her mother, sends the receipts to the trust, and the trust can pay the daughter back for making those purchases. And these are ways that we can help make this trust more flexible and easier for families to use. Now, as far as the process for making deposits into the trust and submitting disbursements, there's a lot of technological advancements that many trusts have made. Most trusts, you can now send your deposit on a monthly basis electronically by providing us with your bank account, routing information, and picking a day that you'd like the funds deposited into the trust on a monthly basis. You can also mail a check if that's something that someone's more comfortable doing. It certainly takes longer for the funds to get to the trust, and you have to remember to send it every month. So we typically encourage people to participate in electronic deposits if that's possible for them. So on a monthly basis, their spend down deposit is going to be going into the trust, and you can see there's a nice graphic here on the right to try and help illustrate this for everyone. And then they're going to submit requests to the trust, and these can be to pay for a one-time expense like a utility bill that's going to fluctuate from month to month, or perhaps a cable or cell phone bill, but it can also be for recurring expenses, things that that are fixed expenses like a rent or a mortgage, where it's a set amount of money, it's the same amount every single month, and you can provide some documentation upfront to the trust, and we can set that up to be paid automatically each month. And that can really help make this process much faster and simpler for families, especially if, let's say, going back to our example earlier with Hilda, she has a $500 spend down. She deposits that spend down electronically each month, and then we use that $4 she has left approximately each month to pay towards her rent. That way, we're paying the rent automatically each month, and we're getting her deposit automatically. It automates the entire process for her. Now, that doesn't work out necessarily for everyone, but we certainly do encourage people to consider there are a number of different automatic payment options that you can take advantage of. Other suggestions would be to identify, a set of bills that you want to use the trust for on a month-to-month basis. That way, every month, that's the bill you're going to send. You want to try and identify some larger bills that, again, if it's a $500 spend down, if we can pay $250 towards the electric and $100 towards her cable, and, the remaining money she might use for groceries. Those are ways that you can identify the right bills for your particular situation to minimize the amount of work for you as far as submitting requests to the trust on a monthly basis. So your money's in the trust on a monthly basis, then you're sending in your requests, and the trust is going to review those requests, and for approved disbursements, they will dispense the funds to a third party based on what is available in the account. Now, in that way, and I just want to mention that too, this works somewhat like a checking account in that what you have in your trust as an available funds is what you have to pay for bills. Once you have expended all that money, there is no more money left in the trust for you to use to pay for other bills, and you would then have to use the money that you have on hand and that you get to keep each month for your other expenses. But we do have people who have larger spend downs and on a month-to-month basis may not spend all of their money. And that is perfectly okay. Currently, the funds will roll over to the next month, and when you make your next deposit, it just simply adds to that balance to be used for future expenses. Now, there's lots of ways that people can monitor the activity in their trust account. In our program, we are very proud to have a team of customer service reps who are available on weekdays from 8 to 5 to answer any questions that someone has and to assist people with the day-to-day management of their trust assets. We can provide multilingual customer support if an individual needs that. And we offer a variety of tools that can help people monitor their account even after hours and at their convenience. By calling things like an automated phone line so they can check their balance, track when payments are going out. And we also have an online portal where people can log in and view the details of their trust account at their own convenience. That's something that can be available to a family member who's assisting a loved one as well. We also will provide monthly statements to the individuals to track the activity in their account. And when it comes to reporting to the various government agencies, when you are performing annual recertifications, or perhaps to simply verify that deposits are being made on a regular basis, the trust can support the individuals through that process as well. Now, this is a thorough overview of how people are able to use pooled trusts currently. And in light of the forthcoming changes to the new Community Medicaid, we do want to point out that while these changes have been delayed and will not necessarily be implemented until it sounds like potentially January of 2021 at this time, these non-exempt asset transfers that are made after October 1 could still potentially be subject to a look back. There is now going to be a community-based look back period, as Ann-Margaret alluded to earlier, where they are going to review when someone goes to apply for community-based long-term care services specifically, they are going to look back to October 1st of 2020 to evaluate if they made any non-exempt asset transfers during that period of time. And those transfer rules apply both to assets and income as well. And so this is, where we're in the process of, evaluating this, because for people who are over the age of 65 and using a pooled trust now, they're able to deposit their spend down on a monthly basis, and they don't have any sort of transfer penalty because there has previously been no look back period for Community Medicaid. And they only have to worry about if they go into a nursing home in 5 years. And when they go into a nursing home, as long as they used the money in the pooled trust for items and services for the benefit of the individual, they will typically not be penalized for those transfers that they made while they were on community-based Medicaid benefits. I do also want to point out that there will be no look-back period for basic Medicaid services, and certain waiver services as well will be exempt from this community-based look-back period. However, again, once someone goes to apply for the services after January 1 is when they'll begin looking back to October 1st of 2020 to see if there were transfers made. And so I want to make sure that people are aware that the usual exceptions still apply. There are exceptions that you can appropriately transfer funds for Medicaid eligibility purposes. One of those exceptions is if the person is under the age of 65, there is no transfer penalty for funds that are deposited into a pooled trust or S&T for their benefit. So if we're talking about the elderly community, someone who's over the age of 65, that they are able to transfer funds, but they must use a pooled trust in order to deposit any future income or assets. And going forward, we are waiting to learn more about this process, but what we've been told is that Medicaid may review the trust on a periodic basis to determine if the individual is in fact spending the money down on a month-to-month basis. It might be something that they look at quarterly or annually. Certainly at the annual recertification would make sense to me, but that's something that we are certainly in conversations about now, and we encourage you guys to provide us with your contact information. Follow us on LinkedIn if you don't already, because we will be providing updates as new information becomes available regarding these new Community Medicaid look-back rules. So I think just in summary, at this time, people are absolutely still encouraged to use a pooled trust, and the Department of Health has alluded to the fact that they will continue to allow this going forward. But what this means is that it's even more important that people are using the money on a month-to-month basis. This is a program that the whole idea is that you're putting the money in to support your ability to stay in the community. So on a monthly basis, you should be using that money for your expenses. But one of the things we really are trying to point out to the Department of Health is that there are other expenses beyond your monthly expenses. There are things like unexpected expenses that might come up. There are things like property taxes that don't necessarily get charged monthly. And so there are reasons why someone really could not spend down all of this money on a month-to-month basis. So that is something, certainly that we would like to see continue. It's very important that people are able to continue to utilize these programs and be able to use the funds for not only their living expenses, but non-covered medical expenses that might come up as their care needs progress over time, and also, unexpected expenses. So those are things that we're still waiting to hear more with regard to how that will be treated, and we will certainly update you along the way as new information becomes available. So with that, I'm gonna wrap things up and open up for questions. If anybody has questions, they want to unmute themselves, or Brianna, if you have any questions that have come in the chat that you want to start us off with.
Hi, yes, hello. My name is Colette, and I have a question. I wanted to ask about protecting your asset with creating a life estate, a deed transfer with a life estate. How does that protect you from losing your tax exemption, your star credit, and any veteran benefits with the deed transfer with a life estate?
Okay, so those of you who do not yet have a life estate, put your pens down, don't take notes on this, because if you don't already have one, you shouldn't create one. If you already have one, I used to do life estates for clients before 2006, because the look back period for trusts was always 5 years. Before 2006, on a life estate, it was only 3 years. So it had this one little advantage, and that was the time period. With a life estate, I take the deed, I transfer it to my 3 kids, but on the deed, it says subject to Ann-Margaret Carrozza's retained life interest. So for all of the days of my life, I have ownership interests in the property. You got to keep your star exemptions. The negatives with the life estate, and you can tell I'm a little down on it, is A, it can't hold other assets down the road. So remember I talked about this category 3 assets, the savings, the brokerage account, that we're imagining the power of attorney moving back and forth between husband and wife in an emergency. Well, if I'm a widow, one of my first orders of business is to think about putting some of that money now into the asset protection or the hybrid trust, because I no longer have a spouse between which I can transfer assets so quickly. So the life estate is only for that one piece of real estate, number one. Number two, if any of my 3 kids named as the remainder man of the life estate, if any of them have legal liabilities, it will attach to the property. You can't protect the asset the way you can with a trust. Number 3, if you do sell your home during life with a life estate, you're going to get killed with capital gains taxes. We all know that when we sell our primary residence, the Internal Revenue Code gives us a $250,000 capital gains exclusion. I am not, however, allowed to use my full $250,000 capital gains exclusion if I only have a life estate, which is measured by the actuarial tables, the life insurance tables. So if I'm 80, I'm deemed to own 30% of the value of the house because I have a life estate, which is measured by my life. So the Internal Revenue Service gets cute and they say, okay, you can use 30% of your $250,000 capital gains exclusion. So thumbs down on a life estate that's not already in existence because it's subject to the kids' creditors, their divorces. My kids would have to disclose it on a college financial aid form if I have grandchildren applying for college financial aid. Whereas they would not have to do that with the trust because you recall it was not a completed gift because mom held those puppet strings. Anything else?
Okay, so, but the STAR benefit and all of that remains the same.
You keep the STAR benefit, you just get killed with capital gains
The
taxes.
capital gain taxes.
Yep.
Okay, what about for the Medicaid?
Medicaid, it's fine for eligibility. If, however, you ended up selling the home during your life, 30% of the value would go to the Medicaid program. So I would not do a life estate.
Okay. Okay, thank you.
Anyone else? Thank you.
Yeah, I have one. If you are ready to go Medicaid now, but you missed the October 1st turnover of your assets, what kind of penalty do you owe? Let's say November, you're ready to go ask for it. What kind of penalty would I pay? How does that work?
I think we're still grappling with the details of what the penalty is going to look like, but my understanding is that the new law applies only to applications filed after January 1st. So if you were to do your asset transfers and submit a community Medicaid application prior to January 1st, I believe, and I would advocate on your behalf, that you should be held harmless. You should be fine. Just get the application in soon.
How long does it take to make an application?
It's not a quick process, but we're still within the realm where it's possible to submit it by the end of the year.
How about the
I have a
trust?
question. I'm sorry.
The trust, it depends on how much back and forth we have, modeling the provisions, but you can definitely get a trust done within a matter of 2 to 3 weeks. And again, you're retaining the ability to make little changes later on. So it's not like we're rushing for a deadline and then you're stuck with this thing that may make no sense a year and a half from now. You'd still have your date for Medicaid application and eligibility purposes and still have the luxury, if it's properly drafted, to be able to make fine-tune changes later.
Do I have to bring a lot of bank things from before November to you? Would I have to bring a lot of, receipts from the banks?
Oh yeah. Yeah, but if you want more specificity, contact me offline and we can chat. And
Okay.
I've been admiring your bookcases since we started the program.
Thank you.
I have a question. You did my paperwork for me a couple of years ago, maybe 3 years. And I was under the impression that if I needed Medicare, if I needed assistance from Medicaid at home, that nothing would be, I know my retirement accounts aren't charged, but I didn't understand about Social Security. Now, from what I saw with what Sarah said, I'm single, so $875 would be the total amount of my income per month that I could have in order to get home care.
No, if you do the pool trust, you get the
pool trust. The pool trust didn't exist when you did my paperwork, but that was, I'm
right. We're mixing, we're talking apples and oranges. The only assets that can be protected ahead of time are assets. So you're fine. You did your trust a while back. If you were to apply for Community Medicaid, even after the new laws take effect in January, it's taking effect on a rolling basis. So on January 1, that application is going to go back 3 months. So your asset protection that you did with your physical assets was long before that, so you're fine. You can't do a pooled trust before the application, even if you wanted to. So we protected what we could, and you should be happy that you've protected as much as possible.
I'm not finding fault with that. I was just wondering if my understanding is that it no longer applies. My Social Security is more than $875. So if I didn't want the pooled trust, I couldn't get services at home from Medicaid. Is that, unless I wouldn't be eligible. Am I understanding that correctly?
Listen, you're depending upon the amount of the overage, right? Sometimes people have a very tiny overage. If the overage is $20, $50 a month, I say send it to Medicaid with a ribbon on it. You know, it's not worth standing on our heads. But if you have a significant overage, and I hope that you do, it's always going to make sense to go with the pooled trust. Now, we're still grappling with a little bit of uncertainty. We don't know what this is going to look like, and we don't even know for sure if they will impose a penalty. We don't have final regulations and a nuanced understanding of how this is going to work. So feel good about what you did so far, and we will provide you with the best information when we know it.
Thank you very much.
Know that there are options available. It really does come down to how much your spend down is, what's going to be the best, option for you. But there are options available.
Sarah, I don't know if you noticed, but I emailed some questions to you that you would be able to answer regarding pooled trusts and Medicaid.
Yes, thank you, Brianna. I appreciate that. We do have quite a few questions, so I'm going to try and run through a few of them really quickly. And certainly if there's anyone that has to jump off, we understand. Please feel free to send us an email if you have additional questions, or give us a call if you want to talk about things offline. So there's a question about using the pooled trust if the beneficiary and their family does not receive what's left over, if that's correct. And then of course that it's important then to spend down the money in the trust. Certainly that is the case. As I mentioned, this is an irrevocable trust, and it is a first party trust. So there's a payback provision in the trust that any amount of money that does not go to repay Medicaid for the lien would be retained by the trust. Now, keep in mind, someone is depositing their excess monthly income at the beginning of the month. They're typically using the majority of that money during that month to support their living expenses. We're not talking about a large amount of money that could potentially be in the trust. If you have a family member or a person you're working with who may have a balance in their trust, there are lots of ways to help spend that down. Perhaps setting up a irrevocable pre-need funeral arrangement to use some of that money to ensure that there is not a large balance in the trust, either at the time of someone's passing or at the time that someone goes into a nursing home as well. That's also, very important. So yes, the answer is no, the funds will not be able to go back to family members, but this is your income on a monthly basis. That's typically going to be used for your living expenses. So the benefits of using the pooled trust and getting to utilize your excess income while you're eligible for Medicaid services, far outweighs any small balance that may be in the trust upon the beneficiary's passing. There were also some questions about the Medicare savings program. So there's a question about whether or not the pooled trust or other irrevocable trusts for an individual can help them be eligible from the Medicare Savings Program. It's not necessarily the pooled trust that makes someone eligible for that program. However, being eligible for the Medicare Savings Program, where Medicaid helps offset the costs of someone's Medicare Part B premium, can certainly be beneficial to someone who's evaluating a pooled trust as an option for them, because by being able to get the cost of their Part B premium covered, that's around $135 to $150, forgive me, I don't know the exact number, a month that they now are not having taken out of their Social Security check anymore. So that getting that Medicare Savings Program in place can help offset the costs of using a pooled trust in certain situations. However, the requirements to qualify for Medicare Savings Program are financially based. So you have to be eligible for that program in order for that to benefit you. There's a question about if the trust beneficiary can have their disbursements deposited into their loved one's ABLE account, or does it have to be a credit card? I'm assuming that we're referring to a situation where someone is going out and buying something on behalf of someone else. It certainly would not be able to reimburse we can reimburse a loved one into their checking account. If they make a purchase on a credit card, we can reimburse their credit card. ABLE accounts are a very different type of account. Those are available to people who are disabled prior to age 26, and another tool to help someone maintain eligibility for benefits. So that gets very complicated. There wouldn't be a situation where the trust would typically reimburse to someone's ABLE account. However, that is certainly a topic we could spend a whole nother hour and a half talking about. So if you want to learn more about ABLE accounts, I recommend that you contact me or certainly enroll in one of our upcoming webinars. We do an S&T versus ABLE account webinar that would be happy to share more information about that program. And there's a question about penalty for transfers into a pooled trust. And as Ann-Margaret alluded to earlier, we really don't have enough information, to know how something like that would be calculated. And again, if there even will be a penalty imposed. The CMS manual for Medicaid states that funds that are deposited into a trust and the pooled trust uses that money to purchase items and services at fair market value for the benefit of the individual would not be subject to a penalty. And so again, as long as people are using their money when they go to recertify or at what time they review the account, the penalty would not apply to funds that were used for the benefit of that person. So that's really what we know at this time. And again, we'll have more information hopefully in the future about whether and if at all there is a penalty imposed for transfers into a pool trust. Do keep in mind, if someone's under the age of 65, there is no transfer penalty. It is just for transfers that are made once someone is over the age of 65. Ann-Margaret, I think this question may be for you. It's regarding required 2020 IRA distribution. Since the requirement has been waived for 2020 due to the pandemic, is it more beneficial to still take the 2020 distribution and have it transferred to an S&T or a pooled trust that has not yet been established, but will be in the next 60 days?
It depends on when you're going to be submitting that application. So typically the decision as to whether or not to take an RMD in this unprecedented year where it has become optional, you would normally discuss that with your accountant, and the traditional income tax advice would be not to take it because you want to defer the inherent gain as long as possible. However, when I said that the retirement accounts are invisible or protected, the RMD that it throws off every year is not protected. So when we apply for a Medicaid program, that required minimum distribution divided by 12 is going to be folded into our monthly income budget. So the short answer is do whatever the heck you want if you're not going to submit that application until after January 1st. If you want to submit this year in order to protect the corpus or the principal, then it will be necessary to pull out the RMD.
And Ann-Margaret, another one for you regarding if you have an irrevocable trust, but you change it to a hybrid trust, do you have to restart the 5-year look-back period if you've already passed the 5 years?
Okay, well, it depends on the type of trust. So you could have 100 different types of trusts. I would definitely have to look at it, but I can tell you as a general proposition, if you have a revocable trust, and I think we were all clear on the logical basis for nothing in a revocable trust being protected vis-a-vis my creditors, right? If I can pull the stuff out, then the nursing home can have all of the assets. So there's no such thing, yet every day of the week, people come into my office asking to convert their revocable trust into an asset protection trust. And you're just starting over at that point because the revocable trust gives zero protection. If you're saying you have a trust, that's too irrevocable, well, yeah, then your 5 years should have come and gone. And there are tools within New York state law to, I say, puncture some air holes into that terrible, purely irrevocable trust to make it a little more breathable and make it a hybrid trust. So we can go from overly protected to sufficiently protected, but we can't go from totally unprotected to sufficiently protected without a new 5-year.
Wonderful, thank you. And so we did get some questions too regarding the determination of disability, and I'm happy to touch on that. And Ann-Margaret, if you have anything to add, feel free to jump in. So when someone is an older individual who's looking to qualify for Medicaid benefits, they may need to fill out some paperwork and submit that with their Medicaid application to determine them as disabled. There are 3 forms. One needs to be filled out by a physician or a doctor, and the other forms can be filled out by a family member or a caregiver. I do not have access to those forms. I don't know if Ann-Margaret, if you perhaps have them on your website. Those are things that you can obtain directly from the Department of Social Services, ask them about and get copies of those forms or ask them if it's necessary for you. And as far as the time frame that takes, it can take quite a bit of time. I don't know the exact requirement, and you may know, but it's along the same lines as the length of the Medicaid application. It tends to be a longer process because those forms are submitted to the state review team to deem the individual disabled. However, I would say this is a very different process than applying for disability benefits. I have not come across a single example where someone has not been approved that has applied for this particular determination. And then Ann-Margaret, there was a question with regard to unless you need immediate need for Medicaid services, it should be a month to get Medicaid. And it says something about 10 days before the first and usually 3 months to process. Did she get that correct?
Yeah, so our time frame right now with the community Medicaid applications has been about a month. So just in general, immediate needs, you can do it even sooner. I do. If I can, there was just one point that I didn't really get into in the earlier presentation, and that was protecting assets vis-a-vis marital breakups, cohabitation breakups, and I think today, if we enter into a marriage or even a cohabitation situation without some legal protections in place, we're out of our minds. And this is especially true in a second marriage or a third marriage, where the divorce rate is in the 40% range for a first marriage, second marriage and beyond, it's over 60%. So it's critically important that we start thinking, without snickering at it, we need to start thinking about doing prenuptial agreements. And we need to encourage our children to do the same. Now, when our children are adults, they can do what they want. They're madly in love. They're not thinking clearly. They want to, throw their lot in life together with the new person. However, within the documents where we name them as beneficiaries, I think it's perfectly appropriate for me to say, I leave everything to Mary, Susie, and Johnny with the hope, or I can be a little harder and I can say on the condition that they take legal steps to keep these assets inherited from me, thank you, to keep these assets separate from assets they choose to commingle with a partner or a spouse. That's going to do a lot to keep the assets separate if they do divorce or have a contentious breakup. Now, New York State law, this is what we call the black letter law. And if you're on a game show, the correct answer is that gifted or inherited assets are considered to be separate property. However, New York State has not community property laws, which is easy to understand. It's half and half. New York State has what's called equitable distribution laws. What does that mean? Well, it means it's the Wild West, and the judge, sitting at your divorce action gets to do and gets to rule on whatever the heck property distribution he or she feels is necessary to achieve equity. So if I look like his ex-wife, are we going to have him leave his prejudices at the doorstep? I don't know. But if we can show these documents, it's very helpful. Along those lines, and this will be my final point, because this subject causes more of the will wars that I see than anything else. And that is, I helped my daughter with a down payment on a house 15 years ago. I gave her $100,000. And then she was going to pay it back, and, life went on, and I kind of brush it under the rug. Well, when I die and my trust says they get everything even Steven 3 ways, you can be sure that her 2 brothers are going to say, hey, we need to make this equal because you already got $100,000. And she's going to say it was a gift. And they're going to say it was a loan. Should it be a gift? Should it be a loan? It should be whatever you want, but you have to have the courage to deal with it. If you want to give her a free pass, let everyone know that. Put little language in the trust or will that says intra-family debts will be forgiven, or not. If I want to make it equal, then I'm going to give the other 2 $100,000 right out of the gate, so that they're all on similar footing, and then I'm going to split everything 3 ways. But the better way for me to help her with the down payment would be in the form of a loan in writing, because if that marriage does not work out, I want to be able to pull my $100,000 back and not have it split with my soon-to-be son-in-law. And you can only do that if you have this in writing. So very important to dot the I's and cross the T's.
Wonderful, thank you, Ann-Margaret. And I think just we did have just one other question with regard to NYSARC's application, and trust documents are available in other languages for those who might not speak English as their first language. We do have our documents available for those that speak Spanish. So certainly we would encourage you to contact us if you'd like a copy of those to review. Those are for translation purposes and can be of assistance. They're also on our website. We have brochures, trust documents, and our forms, all in Spanish as well. And if you have someone that speaks another language, we do have an interpreter service that can work with individuals with over 100 different languages, and we can certainly connect someone so that we can have a conversation where we can translate the information and give people the general overview of how the trust works. We certainly have a number of people who are not English speaking as their first language, primarily Russian, Spanish, and we do have some other dialects as well. So definitely those are available, and if you'd like more information about that, I'm going to put my contact information into the chat now so that anybody that has additional questions after today's training can reach out if you have something that you'd like to discuss in more detail as far as a specific client or your own family situation, or any other questions in the future. I know we went over a lot of information today, a lot of really complex topics. So please do reach out to us if you have other questions in the future. I am going to work on I appreciate everyone that put their contact information into the chat. I'm going to work on getting the recording available to everyone to share with those who have requested it. And with that, Ann-Margaret, is there anything else? We have a raffle we would like to do. We do.
Yeah, so again, anyone who wants to enter the raffle for the book, Love and Money, Protecting Yourself from Angry Exes, Wacky Relatives, Con Artists, and Inner Demons. Okay, that's the correct graphic. So jump onto my website and you can email me directly from there. There's a link, and the website is myelderlawadttorney.com. And let me know if you want to be on my list for updates. And it was really such a wonderful, informative program today, and I hope that everyone got a lot out of it. And Sarah, you're just like a master on pooled trusts, and I hope that we can do this again. And it's all about sharing information with each other. So I would say that the folks who were on the program today, you are more informed than other people, but I hope within your communities and networks, you go out there and tell people that the laws are changing, because a lot of people are going to be unpleasantly surprised early next year. So with that, thanks so much.
Thank you. Very informative. Thank you.
Thank you. So long, everyone.